Hi everyone, this is Vasilia, Mentor Lawyer's sidekick, aka Ladybug. Anyway, in this video, you will get to see me for the first time. Well, if you hang around to watch the awesome reenactment Mentor Lawyer and I did of the closing arguments in the trial of the state of Florida versus Thaddeous Austin Warrington. First, let me introduce you to the main subject of this video, the smart one of the three amigos, Mark Velez-Amador. That's him on the screen, waiting for the interrogators to come in. And shortly you will see his super fast interrogation and learn why we call him the smartest of the three amigos. At the end of the interrogation portion of this video, we will show you a reenactment of the closing arguments from the trial. But before you watch that portion, we need to give you a few caveats. First, I am not an actress or a lawyer, and this was my first reenactment ever. Anyways, Mentor Lawyer did instruct me to give you one caveat for him. He thought that the closing argument by Warrington's defense counsel was quite weak, and he wanted me to remind you that the closing arguments that he is reenacting are not reflective of Mentor Lawyer's own qualities as an attorney. Please remember that he's simply playing a part, and that someone else uttered that closing argument. Those words that he will read to you during the reenactment. Well, that is all for caveats. By now you know this case. This video, of course, about the awful murder of Malik Brown, which occurred in Kissimmee, Florida on May 23, 2020. Immediately after the murder, the three people involved fled the scene, the so-called three amigos. Thaddeous Warrington, who's 19, his girlfriend Lana, who's 17, and the final amigo, Mark Velez-Amador, who's 24. After their post-murder adventures, the sleepy trio were caught together in Lana's vehicle in Daytona Beach, and they were each taken to an interrogation room. This is the interrogation of Mark Velez-Amador. There will be additional videos in this series, and you will eventually get to hear Mark's full story of what happened. Please remember to let us know in the comments if you want more reenactments from the trial in this case. We could reenact the testimonies of Mark, Lana, and Thaddeous, but only if you insist. A lot. Alright, please don't forget to like the video, if you like it, of course. Comment, subscribe to all of our channels, and hit the notification button. Here's the interrogation of Mark Velez-Amador, followed by our reenactment of the closing arguments.
Hi.
Hello.
Mark?
Yes, sir.
Hi, I'm Detective Quinn. This is Detective Cortez.
Nice to meet you.
How are you doing?
Good.
Good.
We're out of Osceola County.
Yeah.
I know it's been a long day for, I think, both of us.
Yeah.
Right? You look tired. Do I look tired?
Yeah.
How about me? Or does I look old and wrinkly? Just kidding, man. Go ahead.
How are you?
So, good. Like you said, we're from Osceola County. Before we go any further and get started, I'm just going to read you something, okay?
Okay.
You have the right to remain silent. Do you understand? You have to speak.
Oh, yes, sir.
Okay. Anything you say may be used against you in court. Do you understand?
Yes, sir.
You have the right to an attorney. Do you understand?
Yes, sir.
If you cannot afford an attorney, one will be provided to you free by the courts. Do you understand?
Yes, sir.
Okay. At any time during this interview, you can stop talking, request an attorney before, during, and after questioning. Do you understand?
Yes, sir.
Okay. That being said, everybody else told their story. We already know what's up. So we're going to give you a chance if you want to re-engage us and talk to us and tell us what happened.
I would like to talk to a lawyer.
Okay. Alrighty.
No problem.
Yeah.
So I don't know if you're gonna maintain those handcuffs in front of you.
Yeah.
Okay. The clothing is probably gonna be taken away.
Yeah.
And they'll probably give you clothing. But that clothing that you have and everything you're wearing is gonna be taken away. And then they're probably gonna do like fingerprints. I'm just letting you know what's gonna happen next, okay? The fingerprints, DNA, and stuff like that, okay? And if 99.9% sure a warrant's going to get drafted, and then we'll go from there, okay?
Yeah.
Just want to let you know. Sounds good?
We got it. Okay.
Thank you. Good morning, everyone. I want to thank you, first of all. I know myself, the defense counsel, the defendant, the court all realize that it's not easy to take an entire week out of your life. Everyone's busy, so we do appreciate you being here with us. We do appreciate your attention. You've all been very attentive during this entire case. I know a lot of what was discussed. A lot of what was seen was not something that was easy to look at or easy to hear about. You sat through an entire case that involved the death of a human being. You had to watch a video that showed the homicide, albeit far away or grainy. But you did have to watch the video. You had to look at some pretty, not easy to look at photographs. So we do appreciate all of your attention in this case. This is an important matter, so that's what I wanted to tell you first. Thank you. Second of all, the judge told you, and we kind of discussed in the beginning, that the burden is on me and my co-counsel. The burden never shifts from us. And we are supposed to prove the case, and we have to prove a case beyond a reasonable doubt before a defendant can be found guilty. Before this defendant can be found guilty. I submit to you, based on all of the evidence and all of the testimony that you have heard, the state has met its burden in this case and proven beyond a reasonable doubt that the defendant killed Malik Brown. Some of the things that I wanted to point out, the judge went over in the jury instructions, and the judge went over elements of the case. One of the things that I want to point out is for count 1. The judge told you, you can find the defendant guilty of first-degree murder. You can find the defendant guilty of the lesser of second-degree murder, or manslaughter, or find the defendant not guilty. And one of the things is the first element in first-degree murder. Second-degree murder and manslaughter is that Malik Brown is dead. That has been stipulated by the defense and myself. The judge read you a stipulation before Dr. Stephanie testified that says we all agree that Malik Brown is dead. So that's not an issue before you. For first-degree murder, the state has to prove that the defendant committed a criminal act, and the defendant committed that criminal act with the premeditation to design and kill Malik Brown. Okay, so we know that Malik Brown is dead. We know that based upon the testimony, evidence, video, everything you guys saw. The state submits to you that we have proven that the act was done by Thaddeous Warrington. Premeditation. The judge read you the instruction, but there's just a couple things I want to go over. So the judge told you that premeditation is a killing after consciously deciding to do so. I know a lot of us think planning and organizing and that kind of thing, but premeditation can actually happen in an instant. Think of it this way. Let's say everybody here lives in Florida. Everybody lives in Osceola County. So mosquitoes are here, and a mosquito lands on your arm. You have 2 choices, or actually 3 choices. You can let it finish what it's doing and fly away on its own. You can shoo it away, or you can kill it. All right, that's premeditation. Premeditation can happen like that. Premeditation is killing that mosquito. There's no time limit that the state has to meet. There's no sensitive planning that has to occur for premeditation to occur. So let's look at some of the things we know in the case. I would submit to you now, based upon the testimony of Lana, who was present, Mark Velez, who was present, and the surveillance video in this case. We all know that all 4 of the people were standing in the driveway. It was about 2 in the morning. Some kind of disagreement happens. There's testimony before you that Malik Brown was upset. 1, they were supposed to pick him up from work, and they didn't. And 2, when he gets home, they're using some of his stuff, his Bluetooth speaker. Mark Velez told you they had been drinking. All of these things. So Mr. Brown was upset. Nobody ever told you there is absolutely no evidence that Malik Brown got violent. There's no evidence that Malik Brown had a gun. There's no evidence that Malik Brown had any type of weapon. I'll submit to you that the video we watched yesterday that was looking at the house, but was kind of far away, we had to zoom in. You'll have an opportunity also to take all of that stuff back into the deliberation with you. A laptop's going to be sent back there, and you can watch it if you want to. You don't have to, whatever the case may be. You'll have the opportunity to rewatch the videos if you want. There is no sign of struggle. There is Malik Brown standing there, and then Malik Brown is rolling into the road. Something else that I want to point out to you about these videos. You had the opportunity to see Mark Velez, and you had the opportunity to see Lana, and you have the opportunity to see the defendant. And I would submit to you that there's a significant size difference between all of the people that you're going to be able to see in this video. And I would submit to you that based upon that video, it's obvious. I would submit to you that Thaddeous Warrington is the one who does the shooting. You see in the video Malik Brown rolling to the road. I would submit to you that he is still moving. His legs are moving. Mark Velez told you that his hands were moving. Malik Brown is still moving. And you heard from Dr. Stephanie, something that I asked Dr. Stephanie. There's 2 gunshots. One, Dr. Stephanie said, death would likely be immediate. One on the side of the head. And then there was one to the mouth. And the mouth, Dr. Stephanie said, it didn't hit any vital organs. It didn't hit the spinal cord. It didn't hit any major arteries. I would submit to you that that was shot number 1, in the mouth. And that is why Malik Brown was still moving on the ground. Defense did ask about twitching and things like that, but I really want you to pay attention to how much Malik Brown was really moving. And it was at that point that the defendant, I would submit to you, very nonchalantly walks up, stands over Malik Brown's body, and shoots him in the head. He then dragged Mr. Brown's body and puts it in the trunk of the car. Mark Velez did help Mr. Warrington put Mr. Brown in the trunk of the car. But something else that I want to point out from that faraway video, you can see Lana panicking. She runs from over by the car, over to the side of the house. You can see her going back and forth. You can see, I would submit to you, Mark Velez run to the side of the car as the defendant is dragging Malik Brown to the car. I will agree that it is difficult to see because it is far away. But spend some time looking at the video. That video is very consistent with what Lana told you in court and what Mark Velez told you in court. And after that happens. The first shot happens about 1:51 in the morning. The second shot happens about 20 seconds later. Mr. Brown is put into the trunk of the car. The car leaves about a minute after the first shot. The defendant spends at least 10 minutes with the hose, with the towel, with the blanket, trying to get rid of what was in the roadway. And the defense asked a couple different witnesses, did you find any projectiles? Did you find any projectiles? And everybody said no. The water went all the way to the sewer drain. It's reasonable that the projectile washed into the sewer drain with some of Mr. Brown's blood. The defendant removing Mr. Brown from the place where he killed Mr. Brown is tampering with evidence. The defendant very obviously and clearly knew that an investigation was going to take place. Fired 2 gunshots in a residential neighborhood where you had the opportunity to see that all of the houses were kind of close together. Surveillance video was on the house like 2 doors down. There's surveillance video. His actions very clearly demonstrated that he knew that there was going to be an investigation. The defendant not only removed Mr. Brown's body, he left the scene with the gun. The gun wasn't in the house and wasn't in the car. They drove around with Mr. Brown in the trunk for almost 20 hours. Almost 20 hours Mr. Brown was in the trunk of that car. And there are photographs and evidence that we didn't see in open court that you'll be able to take back there. It's very obvious that Mr. Brown was in the trunk of that car. The shooting happens about 2 a.m. on May 23rd. The value pawn where they go to Tampa, you got the value pawn receipts. That pawning of those AirPods is at 5:33 p.m. on May 23rd. And you're going to take all of that stuff back there. And it's on top of the receipts. There's also a photograph on the Eco ATM receipt. And I would submit to you Mark Velez is very clearly in the middle. But you can see an arm and a figure on the side. Mr. Velez clearly was not alone. Miss Vaughn told you that the defendant and she and Mark Velez were together. Mark Velez told you the same thing. From Tampa, they go to Clearwater. From Clearwater, they go to Ocala. They're in a gas station at Ocala at about 9 p.m. The shooting happened at 2 a.m. Mr. Brown still in the trunk of that car. The second time where the defendant is in the gas station and buys $1 worth of gas. That's at about 11 p.m. on May 23rd. And you heard evidence and testimony that the defendant, Lana Vaughn and Mark Velez, drove that car to that cul-de-sac. The defendant and Mark Velez carried Mr. Brown's body to the woods, poured gasoline on it, and set it on fire. You saw the physical evidence that was consistent with what Lana Vaughn and Mark Velez told you happened. You also see it in the video, the shooting video. And it does take 2 people to put Mr. Brown in the trunk of that car. I'd submit to you it took 2 people to take him out and 2 people to carry him into the wooded area. The judge told you the instruction about principles. So if you find that the defendant is a principal, meaning he acted with another, the defendant had a conscious intent that the criminal act be done. The defendant did some act, or said some word, which intended to and did incite, cause, encourage, insist, or advise the other person or persons to actually commit the crime. The crime would be abusing a dead body. And the defendant and Mark Velez did work together to do that. So even if you find the defendant isn't the one that committed all of those actions, his assistance, his help, his involvement makes him responsible for everybody that was involved's actions. After the fire set, they used gas and set the fire, and the fire spread pretty far through the wooded area. They went to Daytona Beach. The defendant went to Daytona Beach. Ultimately, he was part of a traffic stop by Detective Russell. The defendant was the driver. The defendant had the keys. The defendant was in control of the car. The defense is going to come up here and talk to you about reasonable doubt. The judge told you what reasonable doubt is. A reasonable doubt is not a mere speculative, imaginary, forced doubt. Those types of doubts should not sway you if you have an abiding conviction of guilt. I submit to you that there is no reasonable doubt in this case. Where you can find reasonable doubt is from the evidence, conflicts in the evidence, or a lack of evidence. The defense is going to talk to you a lot about Lana Vaughn and Mark Velez-Amador. There were 4 people there. Lana Vaughn and Mark Velez were 2 of them, and they told you what they saw and what happened. And the defense is going to draw your attention to something that the judge said, because ultimately it's your job whether you find these witnesses credible. We talked about that in jury selection. That's what you have to do. You have to decide whether those 2 people that you don't know were telling you the truth. And you can believe some of what they said, all of what they said, or none of what they said. And some of the things that the judge already told you is that they did have an opportunity to see or know what it is they're testifying about. Well, we know that they were there. We saw them on video. The defendant in his jail cell that you also heard said that they were there and that they were the ones on video. Some of the other things that does the witness have an accurate memory. Is the witness being honest and straightforward when answering attorney questions? Does the witness have an interest in how the case should be decided? Does the witness testimony agree with other evidence and testimony in this case? Is the witness getting any type of preferred treatment? Did they make any prior inconsistent statements? Did they have any prior felonies? Well, Mark Velez and Lana did engage in plea negotiations with the state as a result of this case. They are both convicted felons as a result of this case. They are both serving prison time and have probation as a result of this case and their involvement in the case. But something else that I want to point out is just because they got charged as a result of this case and they are testifying as part of plea negotiations with the state doesn't mean what they're saying is automatically not credible, automatically not believable, automatically not true. You have to consider their testimony like every other witness. But the judge tells you that you have to use more caution because of the facts surrounding their involvement. Plea offers, all of that stuff. So some of the things I want to point out is, was their testimony consistent with the other evidence in this case? And it was. This case, where we just have them testify and that's it, you had some video. You also look at their statements within each other and their statements compared to each other too, along with other evidence in the case. And Miss Vaughn, I would point out, she told you what happened. She told you she was in a relationship with the defendant. She told you that she loved the defendant at the time. She told you that she was 17 years old, and initially she told law enforcement she was inside the house. And it wasn't until the defendant came in and told her, tell them what happened, that she told law enforcement what she told you guys in court, that the defendant was the shooter. The defendant took the gun out of the bag. That's what she told you in court. And the defendant was the one that shot the gun twice and that she panicked and Mark Velez panicked. She told you that in the car when they came back from the gas station. She backed the car into the driveway. During her testimony, she realized, I did not back my car in the driveway. I'm sorry, I lied. I didn't back the car into the driveway. I pulled the car in. Miss Vaughn admitted that she got the part wrong when she was testifying. The inconsistent. There are inconsistencies between what Lana Vaughn and what Mark Velez said about whether they were inside at first and they all came outside, whether the three of them were outside and Mark went back in and got Malik Brown and they came outside. But they're absolutely consistent when it comes to the shooting. Who is outside? How the shooting happens? What happens right after the shooting? How many shots? Where Mr. Brown was shot? What happened after the first shot? And how Mr. Brown rolled into the roadway and was shot again. The fact that Thaddeous Warrington dragged Mr. Brown's body to the trunk of the car, they were inconsistent about who opened the trunk, but the fact that the trunk was open was consistent. Where Mr. Brown's body went, where they went after the shooting. What happened to Mr. Brown's body? All of that is consistent. All of that is also consistent with the videos in this case, with the photographic evidence, with the evidence in this case. The last thing I want to talk to you about are the 2 jail calls you heard yesterday. And some of the things I want to point out, also when Mark Velez was cross-examined by the defense. It was something that was important for them to point out that part of Mr. Velez's plea agreement was to testify truthfully, but also consistent with the proffer that they gave. and the defense was sure to point that out. Something that I want to point out to all of you is some of the things that the defendant said in his jail call. He said that he heard the statements made by Lana Vaughn and Mark Velez. The next thing that he said isn't that they lied. They said that I shot someone and I didn't. He said their statements actually helped me. He said law enforcement doesn't know who's on that video. They think they have a video of me, but nobody can identify me. He says it wasn't planned. He's just going with the flow. He says, nobody can identify me. He also makes it a point to tell the person that he's talking to that. He talks about Lana Vaughn and Mark Velez's plea offers. And he says something that is very interesting. He says nobody had to go to prison if they would have just told the cops what was said. And he says they were impatient. He talks about standing his ground, and he talks about he implies that there was this plan to tell the cops a story. He never says that in Lana's statement or in Mark Velez's statement that they were untruthful. The evidence before you, there is no reasonable doubt that the defendant committed first-degree murder in this case. There is no reasonable doubt that the defendant abused a dead human body in this case. And there is no doubt that the defendant tampered with the physical evidence in this case. Remember, the state's burden is beyond a reasonable doubt. You don't have to check your common sense at the door. You get to take it back there with you into jury deliberations. You're gonna have a chance to review all of the evidence in this case. There's videos and everything. You can choose to review it. You can choose not to review it. But the state's confident, after all the evidence you have seen and heard, all of the testimony that you've had the opportunity to see, that you'll return verdicts of guilty in this case.
Thank you, Ms. Minot. Mr. Johnson, whenever you're ready. Thank you, Your Honor. May it please the court. Members of the jury, I agree with the state. Thank you. Thank you for your time this week. Thank you for your attention this week. We all thank you for your sacrifices over this week being jurors. It has been a long week for all of us. For Mr. Warrington, it's been a long 2 years. What happened to Malik Brown is a tragedy. There's no denying that. But we ask you again to be neutral fact finders in this case. We ask you to do your job as jurors. As we have said from the very beginning of this trial, Mr. Warrington is not guilty of all of the charges. Did he try to help out his friend after a horrible mistake? Yeah. Did this group act as a scared group of kids who were panicking? Absolutely. But Mr. Warrington cannot and should not be found guilty of first-degree murder with a firearm. You have heard a lot and you have seen a lot, but you've also heard a lot. And we haven't seen everything. There are holes. There are gaps. There is reasonable doubt. During jury selection earlier this week, and then listening to these jury instructions this morning, you heard that the state, because they are the ones bringing the charges, they are the ones who have the burden of proof in this case. And that burden doesn't just apply to this case as a whole. It applies to each charge individually. Members of the jury, the state has not met their burden of proof in this case. You have heard the evidence and the testimony presented here. and the evidence and the testimony have not proven that my client, Mr. Thaddeous Warrington, is guilty of first-degree murder, is guilty beyond and to the exclusion of every reasonable doubt. Now, we talked about a reasonable doubt is a doubt to which reason can be attached. We have that here. Not in an insensitive sort of way, but in a way that speaks to the truth. The judge instructed you on the elements that have to be proven. Elements that have to be proven by the state, and the state talked about those elements, and you have those copies of those jury instructions. They'll go back with you as well. And also, in those jury instructions, we talked about reasonable doubt. And you heard that reasonable doubt is not a mere possibility, imaginary, or forced doubt. The state talked about this. The judge talked about this. However, if after considering and weighing all that evidence, there is not an abiding conviction of guilt, if it wavers and vacillates, if there is that lingering question that the charge has not been proven beyond a reasonable doubt, then you must find Mr. Warrington not guilty. Now, the state's right. We talked about it again too. The reasonable doubt. It can come from the evidence, it can come from conflicts in the evidence, and it can come from the lack of evidence. Just one of these is enough to have reasonable doubt. It doesn't have to be found in all three. And remember that while your verdict must be unanimous, you don't have to be unanimous in where you find the reasonable doubt to reach that verdict. You have heard from several witnesses over this week, all of whom have an interest in this case. We heard from law enforcement. We heard from the medical personnel. We heard from investigators. This is a product of their investigation. This is their case. But what they want and what the evidence actually shows are two different things. Again, the state has not met their burden. And yes, we did hear from Mark Velez-Amador, and you did hear from Lana. Two people who have a clear interest in lying to you. We know that Lana and Mark, they have each other's back. Now, like we talked about, we have evidence, conflicts, and lack of evidence where reasonable doubt can come from. And we heard all about that testimony, and let's go through that testimony. The first thing we have is Miss Lana to the stand. We have the evidence that Lana and Mark and Thaddeous, they were in the room playing Uno together. We heard evidence that there was issues between Mark and Malik. We heard that at one point Mark tried to get Malik out of the house. And Mark and Malik were standing at the end of the driveway eventually. We get this conflict in the evidence even as she's testifying about, okay, I'm leaning against the hood of the car, I'm leaning against the trunk of the car, which way the car is pointed. She even admitted on the stand that she was lying. Her words. Now, she also doesn't remember the truck being in the driveway. The truck that we see in the photographs. The Pharaoh scan. And we'll get back to that later. And she says that Mr. Warrington, Mr. Thaddeous Warrington, was not threatened by anyone. She talks about, at one point, her ears were ringing after the shots. And she did talk about Mr. Brown was moving at a certain point. Not crawling, not grabbing, just moving. And there was no evidence that Mr. Brown was talking at this point, saying any words. And she says that Mr. Brown, quote, was shot in the head. Not in the mouth, in the head. And Lana, lack of evidence, didn't see the second shot. She told us that. She says that Mark picked up the body. We have this conflict of she was sitting in the passenger seat and then moving around to the driver's seat, which also comes into play when we're talking about those videos and we see people moving around. She remembers moving around. We have Mr. Warrington was not in that car when Lana and Mark left, and that when they were not all together, when Mark and Lana left, there was that 30 to 45 minute gap in time where they were separated. We have this conflict about going to the friend's house, her best friend's house, to go get some water. We have the evidence about parking in the parking lot with no buildings. We have that she went into her dad's house. She spoke to her dad. She got $10 from her dad. She got a shirt while she was there. But she never contacted anybody for help. She never let her dad know something was going on. We have the evidence where they pawned her AirPods, where she sold her phone after she talked about that she knew she had that Find My iPhone app, and that her family would eventually put out a missing persons report for her, that she wanted to turn the location off on her phone. So that way, she wouldn't be tracked. She didn't want to use her credit card or any card, so that way she wouldn't be tracked. She didn't want to touch anything, so that way it didn't come back to her. We have that once they get to Ocala, she says, quote, they put the body in the trees. They, Mark and Thaddeous Warrington, they did this. Not me. That's what Lana says. But then, we also have this conflict about Mr. Warrington rolled up the body in beach towels. She was clear it was beach towels. It was rolled up. We don't have any physical evidence of that. And we have that Mark and Thaddeous, they were the ones who threw gasoline, not her, again, making sure to distance. And then we talked how at one point during the police investigation, Mr. Warrington was able to talk to her. Police let him talk. And he said, she said herself, that he wanted her to go home. He wanted her to be able to go home. We also have, though, that Mark, Mr. Warrington, and Lana were working together as a team when they were trying to get away with this. When they were trying to figure out, where do we go? What do we do? This is after they're all together. Not one person is telling anybody what needs to be done. Then we have Mark Velez-Amador takes the stand. He says that he lived with Malik Brown, and before living with him, he didn't know that there was going to be any issues living with him. But as you do when you start living with somebody else, you start learning about those little problems that start coming up. Those little tensions that start coming up. And the relationship grew worse. We heard that on the night in question, that Mr. Malik Brown was supposed to be picked up with Lana's car. But while they were playing that Uno, and they are listening to that Bluetooth speaker, they decide, hey, we're not going to pick him up. Mr. Brown, he comes home, and he is frustrated about the fact that he hasn't been picked up. We already have Then he comes in, he is frustrated. Then he walks upstairs and he sees the three of them playing Uno and listening to his Bluetooth speaker. This causes another problem. And we hear that the three of them, they went out to the gas station for snacks. And while they go out to the gas station, he just keeps talking about these problems. These problems. Can't let it go. There was these constant little remarks. And at one point, we hear how Mark went into the store. And now it is Malik, Thaddeous, and Lana are in the car. And we heard about that gun that was now coming into play. That these little disagreements, this is not being able to let go. Now we're starting to get a gun into play. And we learned that Mark learned about that later. Learned about it when they got back to the house. And when we get back to the house and he learns about the gun, at one point all four are standing in the driveway. We have that you that Mr. Velez-Amador wanted to keep talking about. How there's Mark here, Lana here, Mr. Warrington is here, and Malik Brown is here. He keeps saying this you, because he doesn't want to connect this line right here and make it a simple square to say that he was standing right next to Malik Brown. He's telling us on the stand already that he's trying to distance himself from the situation. We can connect that last line. And while they're standing out on the driveway, we start learning about the fact that Mr. Brown, he starts getting more aggressive. He starts yelling more. There's an argument going on. He says that there were verbal threats of, I'm gonna fuck you up. This point, that's when the shots ring out. And we hear that again. Mr. Brown, he's not moving, he's not talking. And we hear that Lana, well, here's another conflict. Lana never went to the passenger seat, according to Mark. Lana was never over there. Lana was just standing up. She was never leaning against the car. Be it a trunk or a hood, whatever it was, she was never leaning. She was just standing. We have these conflicts of what actually happened during this critical moment. And then we hear how they being Lana and Mark, drove off the spot. And again, when they drove off to that spot, 30 to 45 minutes, they agreed on that time. There's 30 to 45 minutes while we were away from Mr. Warrington. And we heard the quote that while they were away from that, they hear the sirens in the distance. They hear the helicopter overhead. The sheriff's helicopter. Quote, what the hell should we do? They're freaking out together. And then eventually Mr. Warrington comes back and we never saw that gun again. Gun has never been pulled up. But we also heard something critical from Mr. Velez-Amador. When Mr. Warrington gets back to the car, he's not angry. He's not threatening anybody. He's upset. Says he shows remorse. He had an emotional breakdown. He started crying. Then, as noted earlier, we have that conflict of best friend's house didn't even come into play. We never went there. We went straight to the dad's house, Lana's dad's house, and we did get that $10, but we don't remember the shirt being changed like Lana talked about. And then he says that they got on the turnpike from Kissimmee, Orlando to Tampa. That doesn't make sense. that doesn't line up. And at this point, quote, we're still trying to decide what to do. And we heard about how they went to go get the gas. They ended up in Ocala. He helped out getting that body into the woods. But now, when that body gets brought back into the woods, wasn't covered, wasn't wrapped up, they grabbed branches, they grabbed leaves, there was nothing else on top, there was nothing else wrapping up the body. That's a conflict. And then Mr. Mark Velez-Amador was careful with his words. He said, we set fire to the body. Again, we set fire to the body. They were working together. Mark Velez hasn't been forced to do anything. He wasn't scared about being along for the ride. He was helping, but he doesn't recall the size of that fire. Doesn't remember that critical moment when that fire got set. And we also learned that this plea with the state, this agreement with the state, and that proffer that we talked about came months after the fact. Not on the day when they were all arrested. It came months after the fact. That's when he finally says, okay, maybe I should tell the story. The next witness that comes to the stand is Deputy Griswold. Now this is where we get that black and white grainy video. That black and white grainy video that we can't see who shot the first shot. We can see a flash, but we can't see a body where that flash is coming from. We can't see if it is the same person who shot the first shot and then the second shot. And we have no sound on that video. No sound to hear that argument. No sound to hear if there was any talking after the fact. Then we have Detective Laverdiere takes the stand. And we talked about how they found cartridge casings, not bullets, cartridge casings, and how it is standard to take those casings to fingerprint them, to analyze them, to swab them. But we never got that back. We never figured out about who was actually on those casings. And then we also have this trash can that we talked about where the rags were thrown into. And we talked about fingerprints there. Don't know about those. Again, lack of evidence. We talked about that spigot that was touched that was still leaking. It was swapped. Don't know what happened there. Again, lack of evidence. Next witness came to the stand is Selena Gomez. I'm sorry. Next. Excuse me. Next witness that comes to the stand is Selena Melendez, a forensic tech. She talks about the FARA scan, that 3D scan that y'all be able to take back and look at. I recommend you look at that closely as well. Look at that while you're looking at the pictures that were taken and presented to see where everything lines up. Because again, we have no bullets on the ground, but we do have the casings, and we indicate where those were marked. But more importantly, we talked about all those spots at the end of the driveway. All those spots that were red, brown stains, suspected blood. But not once in all of that analysis was there an impact crater talked about. A bullet being found. A scruff in the pavement. Nothing about a bullet striking concrete on the ground there. And I'll circle back to that since it is very important. The other thing to remember about Ms. Melendez is remember how she testified on the stand, how she was cooperative with the state, and how she changed demeanor once the defense gets up. She's a member of law enforcement, and the state wants to say they're not invested. But she changes her demeanor on the stand once the questions come from the other side. Then we have Detective Hayes. He talked about getting up to that red car, took photos of the trunk, but he never took fingerprints from the trunk to figure out who actually touched the trunk. We never took any DNA from the trunk to figure out what was going on in the trunk. Lack of evidence. We have Leslie Powers comes to the stand, the arson and fire detective. We talked about those burned debris that were found, not a burned beach towel or anything like that, just burned debris. She can't remember where those samples were definitely collected from. She has a vague memory, but didn't note that down for sure. And we're only going to tell that, yep, gasoline was somehow used here. But we weren't able to collect or test the bottle or the canister that was used for that gasoline. We're not able to see if there's any fingerprints or DNA on that bottle that was used for that gasoline. We're not able to see if there's any fingerprints or DNA on that bottle that was used for that gasoline. We come back again to another analyst Seward. This analyst is the one who looked at the casings, the bullet casings, was able to determine, yep, these casings come from the same gun. We don't know which gun, we don't know who held the gun, we don't know who fired that gun, we just know casings came from the same thing. Great. But we also learned that Florida Department of Law Enforcement also has that fingerprint department that wasn't used with these casings. The casings that would be touched as it is pushed into the gun. Again, a lack of evidence. We have Deputy Malkovsky collects that second video, that video that we saw last. Now, in that video, there's a critical moment that I highlighted. In that video, you have a chance to watch it. When you go back and you watch it, you'll see how there are bodies moving about, disappearing into this gray ether that is the video pixelation. We're not able to 100% track these people the entire time while they were walking around. And more importantly, we get to a certain point in the video where two people are standing side by side at the trunk. Two people, both, you'll see, in white shirts about the same size. Two people look awfully similar at this point. We're not sure who is who at that point. We're not able to use that to track back and figure out who is the one who actually shot. We have Detective Denning who takes the stand, then talks about no firearms located, talked about how they searched the house, how they went to the speedway, how we see who went into the store. We saw people going back into the store, buying a Polar Pop drink, buying a pack of smokes. But again, we're never alerting anybody that there's a problem going on. We're never alerting anybody to help. We're not saying that we're in trouble at this point. And then we have Detective Roses from the Daytona Beach Police Department. And while he talks about coming upon this car, he says that Mr. Warrington gets out of the driver's seat and he gives him orders. Drop the keys. Get back in the car. At this point, Mr. Warrington, he doesn't resist, doesn't run, doesn't hide. He drops the keys and he complies. He complies. He's not trying to hide anything. We have Detective Quinn, who took the stand and talked about, across the interviews that were done, the read technique, about how you try to break somebody down. Beyond that, we didn't get much else from the detective. Now, we then had Dr. Stephanie on the stand, the medical examiner, and we talked about those 2 shots. And this is where we circled back to that forensic evidence. There was that 1 shot through and through on the side of the head, and 1 shot to the mouth. The 1 shot to the mouth was noted that the shot was not fatal, that the shot was not through and through. The bullet stayed in the body, but the shot that went through the brain, the fatal shot, was through and through. That's where we tie it back to those photos and that FARA scan that we're talking about. That's where we talk about the fact that if this was done as stated by the state, that the first shot was the shot to the mouth, and then the second shot was the through and through as Mr. Brown was laying. Standing over the body, shooting into through and through, there would be a blemish on the ground. There would have been a bullet, a scuff, something, a crater, but it wasn't. And you can see that with your own 2 eyes. You can see it in the FARA scan, and you can see it in the photos. That second shot on the ground was not through and through. That second shot was not fatal. We also heard about how the body spasms after it is shot and dies. And after there is a death, that those movements would be seen in the extremities, the arms and the legs. And the state, thankfully, brought out that that would not just be one movement. It could be continuous. When they're saying that the first shot is to the mouth, that wasn't fatal. The second shot was the fatal shot simply because he was moving. That doesn't line up with the expert's testimony. Those movements could have simply been the body reacting after death. And last, we had the jail calls come into evidence. And in those jail calls, we heard who we believe to be Mr. Warrington stating that Mark and Lana should have waited, that nobody should have been in prison, should have waited for a stand your ground motion, hearing. And that lines up with what was said about what happened on the night of. The fact that Mr. Warrington was the mediator here. Mark is the one who shot, and Mark had somebody coming at him aggressively. Mark should have waited for the stand your ground hearing. Instead, he's in prison. Thaddeous was being the mediator. Now, like I said, evidence, lack of evidence, conflicts in the evidence, we have all of that here. And reasonable doubt can come from any of those 3 sources. As members of the jury, it is your job to decide what evidence is reliable. You get to use your common sense to decide what evidence should and should not be relied upon. And one of those things that you look to when determining the credibility of witnesses is, does the testimony agree with the testimony in evidence that came out of the other witnesses? The jury instructions that we have go through 8 different factors that you can look to when looking at, did the witness seem to have an opportunity to see or know that things about which the witness testified? Well, first we have Lana. she needs her glasses. She didn't have her glasses. She didn't see the second shot to see what happened. We have Mr. Velez-Amador not remembering all the details. We have everybody forgetting little details, which comes into play with the second as well. Did the witness seem to have an accurate memory? We're all over the place with what actually happened when it comes to the details, with what is accurate and what is not. Was the witness honest and straightforward in answering the attorney's questions? Well, the state, because they're the ones calling the witnesses, straightforward up to that point. But once the defense gets up, they become combative. They don't want to answer everything simply as it was with the state. That goes to Mark, goes to Lana, goes to every member of law enforcement. You have the instructions. Did the witnesses have some interest in how the case should be decided? That one's abundantly clear here. When it comes to Mark and Lana, we talked about that plea deal. We talked about how little time they're doing. Does the witness's testimony agree with the other testimony and the other evidence? As stated, we went through that. Has the witness been offered or received money, preferred treatment, or other benefit in order to get the witness to testify? Again, clear, Mark and Lana. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? We have those discrepancies in what was done earlier, back in 2020, to now, as we take the stand and try to keep that deal in place. Has the witness been convicted of a felony? Well, we heard about that from both Mark and Lana. You get to look at all those factors, and the state wants you to take Mark and Lana's statements at face value, to just believe what they're saying. Their evidence, the state's evidence, the proof, and the testimony presented over this week does not prove beyond a reasonable doubt that Mr. Warrington is the one who shot and killed Malik Brown. The evidence and the testimony presented shows that it could have been anyone who pulled out that gun, who pulled that trigger. It could have been two separate people. One shot fatal, one shot wasn't. It could have been Mr. Warrington, but the fatal shot could have easily come from Mark Velez-Amador, the person that Malik was having problems with, the person who was the source of Malik's frustrations that led to the conclusion of buying a gun. The person who had Malik come out to the driveway to have a conversation. The person who was standing next to Malik at the end of the driveway. The setting where Malik started to raise his tone of voice and say, "I'm gonna fuck you up." Meanwhile, Lana Vam states Mr. Warrington was not threatened at all. You heard from Mark and Lana that Mr. Warrington was being the mediator. You heard that he was trying to calm everybody down. Where was Mr. Warrington on the positioning in this driveway? In the mediator position between the two warring parties. Which person makes more sense to have gotten angry enough to pull out a gun and pull the trigger? That's reasonable doubt, folks. If it is just possible, if it might have happened, if it could have happened, that's not beyond the exclusion of every reasonable doubt. An abiding conviction of guilt, that's what you need. And I submit to you that based on the evidence that has come out, the testimony that has come out, you will not have an abiding conviction. We have those 30 to 45 minutes. The reason why we bring up those 30 to 45 minutes so much between Mark and Lana is because at this point, over the course of this entire time, the state brings forth evidence that shows that Mark, Lana, and Mr. Warrington are all together. They go into the pawn shop together. They go to the mall together. They go to Ocala together. They're stopped together at Daytona Beach. But there is a 30 to 45 minute gap where Mr. Warrington is separated from the other two, where those two are freaking out. Those two are saying, what are we gonna do? Those two hear the police sirens in the distance. And it was a quiet night, so they could hear those sirens. Those two hear the helicopters buzzing overhead, knowing that they are the ones sitting on a dead body in the trunk. That's when it becomes, what did we do? What do we do? To what did he go? The one that stayed behind. The one who became the fall guy. They came up with a plan. They stuck to their plan, and damn it, it worked. Because they got the deal from the state. They got the deal to testify, and they got away with substantially less time in prison than what they had coming. But the state's story, their evidence, hinges on the testimony from these two people who have a clear motive. Two people who were caught up on their discrepancies on the witness stand as their stories fell apart. And now we're left with the only forensic videos and a video with, again, you have the shot, a 50-50 chance of who is the one who actually pulled the trigger. A 50-50 chance. A shell game. Ladies and gentlemen, a guess, a flip of the coin as to who is the one who actually did this murder. We are left to guess what happened, and that is not beyond and to the exclusion of every reasonable doubt. The state also talked about this mosquito bite. That's premeditation, this mosquito bite. Now, in their world, they want us to believe that a mosquito lands on your arm, you look at it and you go, oh, there's a mosquito about to bite me. Oh no, this is not good. Maybe I should hit it. Maybe I should not. And then hit it. Again, you don't check your common sense at the door. You feel something, you react. You hit it. That's not premeditation. It would be convenient for the state to equate premeditated murder to a simple brushing of a mosquito. But it is two different things. It is because of this reasonable doubt, because of these discrepancies, that we ask you to return the only verdict which speaks the truth and the testimony presented over this case. That is a verdict that finds Mr. Thaddeous Warrington is not guilty of first-degree murder with a firearm. Members of the jury, when I sit down, the state, they get to come back up here. They get to speak to you again. The state gets the last word because they're the ones bringing the charges. And that's okay because that's how things work. That's how the rules work. Members of the jury, when the state gets back up here, listen to every word that they say. And while listening to them, think, does it really make sense? Do I have that abiding conviction of guilt? If Mr. Johnson had the chance to get back up here and to talk about what they're saying, what would he say? What would I say? What would I question? I don't get to counter, but I ask you to think, what would the counters be? The state has not met their burden. Ladies and gentlemen, they have not been able to prove beyond and to the exclusion of every reasonable doubt that Mr. Warrington did first-degree murder. And I submit to you, members of the jury, that you must find the verdict that speaks to the evidence that justice demands. That is the only verdict that makes sense with what you actually saw, what you actually know, and not just a guess. And that is Mr. Thaddeous Austin Warrington is not guilty of first-degree murder. Thank you. Okay. Thank you, Mr. Johnson. Ms. Minell.
Thank you, Judge. The defense is asking you to speculate. The defense said if it could have happened, that is a reasonable doubt. The defense told you Mark Velez-Amador could have shot Mr. Malik Brown. You get to use your common sense. You are the determining party as to what happened. You are the determining party of who to believe, what evidence you believe, who you find credible. The defense told you that the defendant is not guilty of all the charges, but he also told you that the defendant was trying to help his friend cover up what happened. These two statements aren't consistent with each other. There is no lingering question in this case. There is no reasonable doubt in this case. The evidence that you have is that Thaddeous Warrington took a gun, pointed it at Malik Brown, and shot him, not once, walked over to his body, and shot him again. The defense attorney wants you to believe that the shot to the mouth was the second shot because there's no cratering or no mark. I want you to think about what that bullet to the temple had to go through. After it was fired from the gun, it had to enter Mr. Brown's head, go through his entire head, and out the other side, bone twice. Does it matter that there's not a crater in the ground? No. A lot of what the defense pointed out to you as inconsistencies or their arguments are to reasonable doubt, I'd submit to you, are irrelevant. You have to focus on what the state has to prove beyond a reasonable doubt. I don't have to prove to you what side of the car Lana Vaughn got into. I don't have to prove to you whether she was a passenger or a driver. I have to prove to you beyond a reasonable doubt the elements of the crimes. There are 3 crimes charged, you know. That first-degree murder, abuse of a dead human body, and tampering with physical evidence. The elements of each of those crimes are what the state has to prove to you beyond and to the exclusion of every reasonable doubt. The defense mentioned that all of the witnesses were combative with him or her. You all had the opportunity to see all of the witnesses testify. You will all have the memory of how they answered questions, what they said, and you are going to be the ones that decide whether they're credible or not. The last thing I think I want you to think about is the defense brought up this 30 to 45 minute time frame where Lana Vaughn and Mark Velez were sitting in a car. They had a body in the trunk. They're freaking out. They're trying to figure out what to do, and they decide the defendant's the fall guy. And they hear the police helicopter, and they're sitting there. There is no evidence before you that the defendant called 911. The defendant waited for law enforcement to respond. The defendant tried to contact anyone. The defendant is all by himself. What's he doing? Spraying down the driveway, getting towels and blankets, and wiping up the road. That's what the defendant's doing. The defense talked about Malik Brown being aggressive, and Malik Brown yelling, and the fact that the video was grainy, and you can't hear what's going on. What is Malik Brown doing the second time he gets shot? Is he being aggressive then? Is he yelling then? Is he threatening anybody then? No. I would submit to you he may have been yelling at the time he was initially shot, but that's it. and him yelling resulted in the defendant getting a gun from the bag and pointing it at Mr. Brown and shooting him in the head. The defense said Miss Vaughn didn't say, "Shot him in the mouth, shot him in the head. The mouth is in the head." The evidence in this case supports convictions for all 3 counts. The judge is going to tell you in a minute that if you find the defendant guilty, you have to find the defendant guilty of the highest level of offense that has been proven beyond a reasonable doubt. So even if you find the defendant committed manslaughter, even if you find the defendant committed second-degree murder, if you find beyond a reasonable doubt that the defendant committed first-degree murder, that is a crime that you should find the defendant guilty of. The state's confident after you think about all the evidence in this case and all of the testimony you heard and use your common sense, you will find the defendant guilty in this case.
Thank you, Ms. Pinnell. Ladies and gentlemen, we're going to take a 5-minute comfort break.
What's going on, man? Got a few things I need from you. First thing, I'm going to take a couple pictures. You can stand on that wall. Just keep your hands out. Yep, just like that. Perfect. Okay, just spread your hands just like that. Perfect. Nope, just stay just like that. Put your hand up? Yeah, just like that. Turn your hands over. Okay. Turn around, face the wall. Alright, I think I'm good on. Yep. Actually, face me one more time. Oh, face me. Let's get a close headshot of you. Okay. Yep, have a seat. Alright, next thing I'm going to do, I'm going to give you a Q-tip. Just need you to take each individual Q-tip and I'll tell you where to swab it. Alright, this one I need you to do the left side of your cheek. Okay. Can I see that hand one more time? Your right hand? I'm just taking another picture. Okay, so change, leave the clothes there, and I'll be out here just yell when you're done.
good, man?
Yeah.
Alright, put your hands together like this. There you go. Alright, we're almost done. Just have a seat. And we'll be back with you.